Hi everyone, welcome from Law with Dunk, the Law Guy, and today is day 24 of the Case a Day series journey, covering cases across criminal law, tort law, contract law, and the English legal system. Again, always feel free to drop any case requests in the comments section. Also, I know I didn't state this as a target on day 22, but I've just discovered across TikTok and Instagram that I have 250 followers, so I found a reason to wear my Lawlander suit inspired by Homelander. Thanks for the support, everyone. And now with today's case, I'll be responding to Joe's request, a very good friend of mine, with the case of RV Tabassum 2000. The case of RV Tabassum 2000 relates to the law of consent, and I've just checked the OCR specification along with the Year 2 law textbook, and consent is on the syllabus. I'll just say a few things about consent before I cover the case. I won't be able to do the full defence justice here. However, if there are any more case requests linked to consent in the future, I'll be able to add more detail. Now, consent can be used as a defence to some non-fatal offences. However, it cannot be used as a defence to crimes such as murder or criminal offences involving serious injury. However, there is a case I've just read about where a victim consented to a battery that ultimately led to her death, and the defendant wasn't guilty of unlawful manslaughter as there was no battery for step 1 of this offence. Also, people can consent to harm through activities that carry a social benefit, otherwise known as public utility, if it's in the public interest. This covers situations such as sports, games, horseplay, i.e. children messing around and fighting a bit, tattooing, surgery, amongst other examples. Just so you're aware though, consent isn't really a defence due to there technically being no offence committed, as the other person, reluctant to say victim here, has consented. This is clearly illustrated with the hypothetical example of where another person agrees to be touched, such as via a handshake. In this instance, there cannot be the unlawful application of force, and so there is no battery. With RV Tabassum 2000, it relates to the issue of whether real consent exists, specifically the impact or effect of the identity of the defendant upon whether consent exists. In RV Tabassum, the defendant had lied about being medically qualified in order to examine women's breasts. He told them that he was creating a database for research on breast cancer and that they would be participants. He was actually an IT lecturer. He physically examined each lady's breasts and even taught them how to carry out these examinations themselves in order to check for signs of breast cancer. He was found guilty at trial of 3 counts of indecent assault, and he appealed against his convictions, arguing that the victims had consented to his examinations. The Court of Appeal held that consent only existed because the victims believed the defendant to be medically qualified, which he wasn't, so the defendant's fraud denied any true consent. And that's it for today. Thank you from Law with Dunk, the Law Guy, and I'll see you Tuesday, where I'll be covering the requested case of RV Brown.